I'm Tim Perkin, and in this brief presentation, I will be explaining the case of Lotus Development Corporation versus Borland International Incorporated, and addressing the question, is a menu hierarchy copyrightable? Lotus 123 and Quattro were two popular spreadsheet programs in the 1980s. Lotus 123 was created by Lotus Development Corporation and included a menu structure allowing users to access commands through a GUI or hotkeys. It also included an original format for creating macros, allowing multiple tasks to be executed quickly. Quattro was created by Borland International Incorporated and came out in 1987 after Lotus 123 and included many more features. Alongside its primary original interface, it included an optional Lotus emulation interface mode, which included the original menu structure from Lotus 123, as well as the hotkeys and the macro format. Lotus viewed this as copyright infringement and filed suit. There was no copying of code or copying of any assets, but except for the menu structure and the names of commands. Both parties agreed that Borland copied Lotus's menu structure. And Lotus showed that its menu structure was not de minimis, which means that there could have been other ways of expressing the same commands in a different structure. For instance, the commands could have been placed under a different hierarchy, or the commands could have been given different but similar names. Lotus claimed that its menu structure was a copyrightable work, but Borland contended that the menu structure is an unprotected means of interfacing with software. The court considered this to be a matter of first impression, meaning that case law had yet to decide a precedent for this sort of case. So it was working only off the text of the law and by cases of different types. The district court found that Borland had infringed Lotus's copyright in replicating 123's menu structure. Borland promptly removed the alternate interface from Quattro. However, the district court would later find that its ability to run 123's macros was also considered infringing. These macros were important to users of Quattro software as for productivity, and removing them would greatly harm the users of Quattro software. So, Borland filed for appeal. In the First Circuit Court of Appeals in 1995, the entire district court decision was reversed, and Judge Stahl ruled that Borland's use of the menu structure was entirely legal. He explained the reasoning for this with an analogy to a VCR remote. Stahl explained that 123 was analogous to the VCR itself and was a copyrightable work unambiguously owned by Lotus. However, the interface was like the buttons on a VCR remote. They were necessary in order to operate the VCR, or the copyrighted program Lotus 123. This constituted a method of operation rather than a quote, literary work, such as computer code. He ruled that it would be ridiculous to expect users to have to learn an entirely different form of interfacing whenever they used a different program that fulfilled the same purpose. Copywriting an interface would be equivalent to copywriting a lever to operate a machine. It's not a part of the work itself, but only a means of using it, and a necessary one at that. So, 123's interface was a non-copyrightable method of operation used to operate the proprietary Lotus software. This leaves us with a few questions. First, is there a clear distinction between the method of operation and copyrightable content in any given instance of consumer software? Second, Should interfaces ever be considered protected and proprietary? Or should ease of use and compatibility be emphasized in our law? Third, is a menu structure unambiguously analogous to the button layout of a VCR remote? Thank you.